The Supreme Court has upheld expanded access to the abortion pill mifepristone, at least for now. Today's ruling does leave the door open for new challenges over this same issue in the future. But for today, the justices issued this unanimous ruling saying the anti-abortion doctors who were fighting to stop expanded access to mifepristone did not have standing to even bring the case in the first place. See, one of the first hurdles you have to prove to get your case heard is whether you have standing. Now, there are several factors to determine that, but one is whether the issue you're suing about is directly causing you actual or imminent harm. In the opinion written by Justice Brett Kavanaugh today, he said, because the plaintiffs do not prescribe, manufacture, sell, or advertise mifepristone or sponsor a competing drug, the plaintiffs suffer no direct monetary injuries from FDA's action relaxing regulation of mifepristone. He goes on to say, because the plaintiffs do not use mifepristone, they obviously can suffer no physical injuries from FDA's actions relaxing regulation of mifepristone. Now, this issue isn't whether mifepristone can be used or sold. The issue in this case was whether the FDA had the authority to relax the rules around access to mifepristone, making it available through telehealth appointments or through the mail. The Fifth Circuit Court of Appeals ruled last year that the FDA did not have the authority to do that. But in this ruling today, the justices are saying that this group of anti-abortion doctors is trying to make a policy change when it comes to abortion medications through the courts. The ruling says that's not how it's done. If this group with no standing wants policy change, they need to do it like everybody else, through the ballot box and through the legislative process. Now, it's important to understand, once the justices decided that the group did not have standing, they didn't go any further. This ruling sidestepped the actual argument. It said nothing about whether or not the FDA had the legal authority to expand access to mifepristone. So that means, while this case is essentially dead, the justices left the door open to another group or another person that does have standing to bring this very same case again with the exact same complaints. And there are already states chomping at the bit to revive their challenges to mifepristone access. The other thing to understand is, since this expanded access to mifepristone was done administratively through the FDA, if another president is elected, that president could, again, administratively change the policy to further restrict the access to mifepristone. So if you want to read this ruling from the Supreme Court, I will email it out to you tonight in my News Girl News Roundup email, so make sure you sign yourself up.